Supreme Court's July 11, 2024 judgment includes far-reaching decisions that will significantly alter local government administration in the country. The Supreme Court has affirmed the financial autonomy of Nigeria's 774 local governments. In a unanimous judgment of its 7-member panel on July 11, the Supreme Court unanimously upheld the suit brought by the federal government to strengthen the independence of local governments in the country. A member of the panel, Justice Emmanuel Agim, who delivered the court's lead judgment, held that the local governments across the country should from July 11 receive their allocations directly from the Accountant General of the Federation. He ruled that it is illegal and unconstitutional for governors to receive and withhold funds allocated to local government areas in their states. He ordered immediate enforcement and compliance with the orders of the courts by the state governments and successive governments henceforth. However, an important part of this judgment appears to be overlooked, and that is the local government tenure elongation. The judgment partly reads, under Section 135, subsection 3 of the Constitution, the tenure of 4 years for the President provided for by Section 135, subsection 2 thereof, shall be extended for periods not exceeding a period of 6 months at any time, by a resolution of the National Assembly if it is not practicable to hold elections. By the same token, by a law of a State House of Assembly, the tenure of local government councils can be legally extended for any reason, such as insecurity or war, if it becomes impracticable or impossible for elections into the local government councils to be conducted. The mandate given to an elected local government council is the mandate of the electorate of that local government area. And if the tenure is extended, it is the people's mandate that is extended. The judgment continues to read, if the tenure of a local government council is truncated, as it is the norm now, it is an illegal termination of the electorate's mandate, and it is not to be encouraged, but roundly condemned. Barrister Sims, what is the interpretation of this judgment?
You see, this particular judgment, I have seen this judgment a long time. I highlighted some points which I recorded here, but I will summarize. One, for lawyers like us who are interested in public interest laws, what this particular judgment has given is number one, where we draw precedent that the Attorney General of the Federation, the Attorney General of any state, 36 states in Nigeria today, have the locus to sue on behalf of the state, on behalf of the federal government, by virtue of Section 5, Sub 1 of the 1999 Constitution, for instance, that gives the executive powers to the president, it is as case may be, and duties to be performed by the president can be delegated to the vice president, it can be delegated to the minister, it can be delegated to his aide, as the case may be. So the Supreme Court in this judgment said, based on that Lateef Fagbemi being the AGF has the locus to put the case. Let me tell you why that is very important. Because the 36 states AG were challenging it. Even a very good learned brother, a PhD holder in law, a lecturer, we argued this thing to a level before this judgment came. I said, no, this is a position. The AGF can sue on behalf of the federal government because of these things. And I'm very happy that the Supreme Court confirmed that. Two, is that they reiterated the issues of clerical mistakes and the issue of signatures. Now, the registrar, I presented my originating summons to file in court. But I signed, I did everything, but the registrar refused or forgot or neglected to put his signature on it. The defendants or respondents in this matter said because of that, non-signature of the registrar, that the writ itself is null and void. The Supreme Court said no, that is not the fault of the man who filed. The man who filed did everything possible, did everything correctly. That it was the court registrar that maybe neglected, I don't know. That you cannot blame the sins of the registrar or any official of court on the litigants. You understand the point? That is what draws lawyers who want to use that as a precedent. They're coming down. The third thing I found out with this judgment was this. A lot of my colleagues and a lot of people who know more than me, were emotional about this. I said that there's a quagmire. The quagmire they're talking about is that the Supreme Court altered Section 7, Sub 1, and even altered Section 162, 1, 2, 3 to 7. So it therefore means that by this particular judgment, that it means that the National Assembly has to tinker with that particular Section 7, Sub 1, and Section 162, Sub 1, 2, 3, 4, 5, 6, 7. Now, I disagree with that. That is not so. A new law need not be created. A new law need not to, these sections need not be amended because the Supreme Court only garnished, let me use the word, they only put Maggi in the soup to make it very sweet and to bring out the qualities of the ingredients we have used. To make Section 7 now explained to us that nobody can obviate it and circumvent it. Let me quickly say, because this particular matter it may take almost one, but I'll cut it in bits. Section 7, if you look at the area, a lot of people have mischievously applied it. They say that why will Section 7 say that the control and making laws for the House of Assembly for local government is vested in the government of the state. Supreme Court now said it's not true. Now look at it. Supreme Court said those who are reading must do a community reading and compulsory reading of Section 7, Sub 1. You don't just take the part that says that and accordingly the government of every state shall subject to Section 8 to this constitution ensure their existence. But you leave the first stanza that says that the system of local government by democratically elected local government is under this constitution guaranteed. That is, the Supreme Court is saying that particular section means that democratic system. When the governor wants to make laws, or House of Assembly wants to make laws, if it is outside the democratically accepted norm, it is null and void. For instance, you can't just come and say, why will I not come? I will not conduct election. You just make law and say, a caretaker committee as case may be. Or you say because you are, no, Supreme Court say you cannot do that. Now, going down to section, 162, so 5, the very controversial one again, they were saying that that is the reason why they have to amend. I wish I had one of those people who were with me on this, who are with me on this panel today, so that we can juggle and we now reflect on what has happened before, as the case may be. That enough that the submission I gave was the correct one. Look at it. The Supreme Court shut down and explained Section 5. That is Section 162 Sub 5 and Section 162 Sub 6 of the 1999 Constitution. Look at it. It says, the amount standing to the credit of local government council's expedition account shall also be allocated to the states for the benefit of their local government councils on such term and in such manner as may be prescribed by the National Assembly. Look at what the Supreme Court said in this thing, because some people have come to say the House of Assembly can make laws, then they just tell the governor that allocation from them local government, he can use it the way he like. No, Supreme Court said the various governors and House of Assembly that be acting, I'm sorry I have to use the word only, they were thieving and stealing the money of local government. That money is not your own. That the money belongs, to the benefit of the local governments in Nigeria. That is the state. So as an assembly, you make law to distribute the finance. You are dealing with money that is not your own. He said you acted as a conveyor to collect the money, just like John the Baptist came to baptize Jesus Christ. He came as an intermediate. That is the way I understand it, to baptize Christ, and that is the situation. So the money is not your own. If you are tumbling with that, you are a big thief in good. That is open and closed. Then I came and said, in subsection 6 of the Constitution, look, I said every state shall maintain special account we call state joint local. That's what they call JAC. Do you know that government before they will just go and set up a JAC All the states do this thing. They go and set up jack that is okay. So a federal government pay to this account. Once federal government pay, they are now saying that it is now left to the governor to decide how to distribute that money to the various local government areas. Now, if local government A is not favorable and is not my fan, I can start to even withhold not giving him money, or I give him, maybe 12 million out of 120 million and say, go and work. Supreme Court is saying no, that this jack account means that you open an account for this particular unit, because we have two federating units. That is what we call federal and the state. They make a federating unit. Supreme Court now came, because the argument came again that yes, we have two federating units, that the local governments were not part of the federating unit. Supreme Court now came, cited Canada, cited America, cited UK, that in the UK, and it is true, I did my research on it, in the US, I did my research on it, the issue of counties and local government are not mentioned in their constitutions. You don't have it in the constitution. You understand? So that fall within the ambit of the state for them to administer local government. Yes.
I really want to come in here, because I've been waiting.
Okay.
Your explanations have become very legalistic. And
okay.
Yes, I will leave that part.
Okay, let's leave the legal part.
That part to the lawyer.
Yes.
But I feel that. Okay, let him.
You can have your say. Yes.
Yes. That point you just raised now practically contradicts a lot of the judgment of the Supreme Court. Yes, it practically contradicts it.
Yes, let me
because there's a point which they even noted in their judgment, that interpretation of the law should not be done piecemeal. You must factor in the entire law. Yes. Good. To interpret a section. Now, interpretation of the Constitution also must depend on fundamentals, one of which is that Nigeria is a federal system of government. And you just got to that point when you mentioned that in the UK and in the US, the business of local government is left to the states.
Absolutely.
The mistake of 1976 is the crisis in local government administration, where the military decided to create a uniform system of local government, jumping the federating units to interfere with what is happening in the localities. And we are extending that crisis. And this will only deepen the crisis.
No, I disagree, Doc.
It will deepen the crisis.
No, I'm coming.
You know what I said?
I disagree. I don't want to forget. I was online when you interjected.
You have some time. Let me tell
you. I disagree with you. I disagree. Vehemently, I disagree. Okay, let me let you land. Yes.
Why it will deepen the crisis is that Nigeria is not a unitary system of government. And the word autonomy, which I've written a paper on that, the word autonomy is equivalent to the word independence. You cannot create an independent part from a dependent whole. You cannot be holding the federal government, the state government finances tied to the federation account. You refuse to allow fiscal federalism, where the state should control their income, their revenue, and pay taxes to the federal government. And now you are claiming that you want to give independence to sub-units, local government, which are not actually federating units. So what kind of thinking is that? If you want to begin to declare independence, allow the states to have autonomy, allow the states control over their resources, pay taxes to the center. The federal government has no business creating a uniform local government.
I want, when you speak, to allow me speak so that we can make sense of this. Excuse me, let me talk. Let me debunk what you are saying, Doctor. I'm coming with due respect. Can I debunk what you are saying with due respect to you, your authority, or whatever your premise? For me, that premise is on a 41. Very pure. Now, let me tell you why it is like that. With due respect, I said to you. Now, let me drop my constitution. Now, let me tell you, first of all, that in the states you are referred to, they practice federalism is not to be called in a particular manner. Like in the UK, they practice democracy. They have their own system of government. In the American system that we have, they practice federalism and democracy. They tailored it in accordance with whatever that is happening in their state. For instance, to elect a president in America, you don't do it by simple majority. You do it by electoral college.
They do electoral college.
It's not part of democracy, part of federalism.
Yes.
The Nigerian, we don't need to do that. India is a democracy and a federalist state. India does not have local government in their constitution. So it becomes two federating unit.
Good.
But in Nigeria, from what scholars have said, is that one, insofar as the constitution has listed, local governments and area councils as the third tier of government, that it has to be operational. They are not dragging federalism with anybody at all. But they are saying that their system of federalism, as the case may be, nurtured by Nigeria, that Japan, India do have, to sprinkle it into whatever as the case may be, that this is what the constitution wants. And you have to follow that particular mode of constitution until and unless the National Assembly makes amendments to make it look directly like the one you practice in America, as case may be. That is the situation.
Can I come in
of
here?
Course, yes.
Good. Now, look at the problem. The 1970 reforms itself was brought in by the military.
Of course I know.
And was wholesomely adopted or coaxed into the constitution.
There's no problem about that.
And the debates continue.
Yes.
And those are part of the problem.
These
constitutions are not actually democratic. They are not really our people's constitution. Now, you have made reference to independent, self-groomed federal systems. Why is our Supreme Court making reference to the United States and to Canada as models?
Do you know why they do that?
Why are they doing that?
The reason why they did that.
Why are they not?
Go to that judgment.
Let me finish.
If you go to page 14 of that judgment.
Let me finish.
They told you how they did it.
Those states created their own systems based on their own internal reality.
Absolutely.
Why are we not creating our own homegrown system? Why are we borrowing that one? And then we are not borrowing everything they are doing in whole. We are borrowing parts to justify our own aberration, to justify our own patterns that
is academic. That is academic. That is what the Supreme Court said. Let me tell you why they refer to Canada, US, and even UK. They said they brought articles written by professors on local government autonomy. That's why I'm saying, if you go to that judgment of Supreme Court, 37 pages, as case may be, read from page 10, 11, 12, 13, 14, 15, 16 to 20 something. You understand why the ratio decidendi. I'm not going to use the legalistic purview now. But what the Supreme Court is saying here, this is our system. And the Constitution says 2 federating units. The Constitution in section 3 sub 1 now come to say in these 2 federating, they are not arguing it. But we have another tier of government.
That is where I'm saying the problem is.